There are four types of bankruptcy that individuals can file. When we speak of bankruptcy types, we refer to them as chapters. The Bankruptcy Code is contained in a large book. Just as the Bible or a novel has chapters, so does the Bankruptcy Code. So, for instance, when we speak of a Chapter 7 bankruptcy, we're talking about the type of bankruptcy created and described in Chapter 7 of the Bankruptcy Code. Of the four types of bankruptcy which are available to consumers, two are very infrequently used and will not be focused on in this discussion. Chapter 12 bankruptcies are only available to family farmers, and Chapter 11 is a very complex and costly type of bankruptcy which is most commonly filed by business enterprises. The most frequently filed type of bankruptcy is Chapter 7. Chapter 7 is a very fast kind of bankruptcy. Usually our clients are in and out of that type of bankruptcy in about 100 days. In a Chapter 7, individuals' unsecured debt like medical bills, personal loans, and credit cards are usually discharged. When a debt is discharged, it is wiped out. The debt is legally no longer due and owing. There are three primary types of debts. Unsecured debts include credit cards, most personal loans, old utility bills, automobile repossession deficiencies, and medical bills. These debts are the easiest to eliminate in bankruptcy. Debts involving houses and cars are usually secured debts. With this type of an arrangement, the creditor has a lien against the property which was financed. In a bankruptcy, the consumer has a choice with this type of debt. If they do not want the house or the car, they can agree to surrender the property, and by virtue of the bankruptcy, the debt will be discharged. If they want to keep the property, if they want to keep the house, if they want to keep the car, they usually only have to keep making the payments. Sometimes lenders, particularly automobile lenders, request that the consumer reaffirm the debt. If the debt is reaffirmed, it means that the consumer is vulnerable to being pursued after the bankruptcy if the payments are not made. We rarely recommend that our clients reaffirm such debts. Another category of debt are priority claims. Priority claims are debts such as restitution, child support, and taxes. Other than taxes, these debts cannot normally be discharged. Taxes can generally only be discharged if a tax lien has not been filed and 3 years have elapsed from the time the taxes were first due. Technically speaking, student loans are unsecured debts, but unlike virtually every other unsecured debt, they are very difficult to eliminate. Persons who are permanently disabled probably have the best chance to discharge a student loan. In order to discharge a student loan, a complaint must be filed with the bankruptcy court requesting discharge on the grounds that repayment would pose an undue hardship. Unfortunately, the law's notion of what an undue hardship is pretty severe and difficult to prove. So, as you can see, the primary focus in a Chapter 7 bankruptcy is the elimination of unsecured debt such as credit cards and medical bills. Chapter 13 bankruptcies are very different from filings under Chapter 7. Chapter 13 bankruptcies are designed to be payment plans lasting between 3 to 5 years. The most common use of a Chapter 13 is to save a house from foreclosure. Under Chapter 13, the foreclosure is stopped or stayed, and the consumers have up to 5 years to get caught up on the mortgage, thus saving the house. Sometimes higher income consumers file Chapter 13 bankruptcies in order to pay off their unsecured debt virtually interest-free, or pay a reduced portion of that debt. Essentially, they are restructuring their unsecured debt. There are many other incentives for individuals to file under Chapter 13, including the ability to avoid some second mortgages, reduce automobile loan balances, and slash tax liens. Regardless of the chapter, all consumer bankruptcies are initiated in the same manner whether they are filed under Chapter 7 or Chapter 13. The first step is the preparation of a bankruptcy petition. The bankruptcy petition is a detailed document which outlines the person's financial condition for the bankruptcy court. Typically, petitions are around 50 pages in length. Before the bankruptcy may be filed, consumers must complete a brief session with a court-approved credit counselor. The counselors charge a nominal fee, and the session can be done over the phone, online, or in person. Typically, the counseling session will take around a half an hour. After the counseling is completed, the petition then can be filed. As soon as the petition is filed, the consumer is totally protected from any creditor activity. No more telephone calls, no lawsuits, and no more collection letters. With a Chapter 7 bankruptcy, around 6 weeks after the petition is filed, a meeting is held with a person called a bankruptcy trustee. A trustee is an attorney appointed to review the petition and hold a meeting with the consumer and their attorney. The trustee's primary job is to verify that the information in the petition is accurate. Typically, this meeting takes about 3 minutes. In rare cases where consumers have valuable assets worth more than the law permits, the trustee administers the sale of some assets and distributes the proceeds to unsecured creditors. We do not recommend Chapter 7 bankruptcies where this is an issue, unless our clients are amenable to this outcome. In order to receive a discharge, the consumer must comply with the debtor educational requirement. Programs have been created providing information about the credit system, which can be viewed online or listened to over the telephone. As long as the educational requirement has been satisfied, the consumer is discharged 60 days from the date of the meeting with the trustee. With a Chapter 13 bankruptcy, the process is largely the same as under Chapter 7. A petition is prepared, credit counseling is undertaken, and then the petition is filed. Included with the Chapter 13 petition will be a payment plan, which details the amount of the monthly payment which the consumer will pay, and the treatment of the various creditors. A meeting is scheduled at the Federal Building in Harrisburg with the Chapter 13 trustee. As with the Chapter 7 meeting, this will be quite short in duration. In addition to holding this meeting, the Chapter 13 trustee is responsible for receiving the plan payment from the consumer and distributing the funds according to the plan, once the plan has been approved by the judge. Once all of the plan payments have been made, then the Chapter 13 bankruptcy is concluded and the bankruptcy may be discharged.